Hey, this is Brian Parker. I got a great video today. This is going to be on my website, collectionstoppersolutions.com. And there are a lot of services and companies on the internet that show you how to do an answer, but they really don't show you. They just give you a blank, non-formatted answer without any explanation. What do? You come to my website, but one of my videos today I'm going to call it Easy Instructions in a Template Form to Answer a Debt Buyer Collection Lawsuit. So what I'm going to do is I'm actually going to give you instructions on each paragraph. So when you look at a lawsuit and you look at the thing that somebody sold you, you can mesh the two properly. I just don't see those instructions there for you online. So I'm going to give them to you. So the top 5 things to remember is take the lawsuit, tear it apart, place false next to each paragraph that you think is false, most of them. True, hardly any. Look at the documents attached that they use to support the lawsuit. It's going to be an affidavit or a fake contract or something combined that doesn't have anything about your specific debt or account number. Highlight everything that helps you, meaning if it's false, wrong, or missing, that helps you. Remember to create affirmative defenses to add to your answer. And the big thing, always accompany your answer with a counter affidavit. And guess what? Those 4 or 5 things I just told you to do, they all go into your counter affidavit, meaning they said something, it's false. The documents they attached, wrong, not my name. It is missing an assignment. And then include affirmative defenses that also incorporate all the problems that you find by tearing the lawsuit apart and looking at the 4 to 12 paragraphs piece by piece. Remember this, inch by inch, anything's a cinch. So don't let this process be overwhelming. I'm going to give you instructions per paragraph. I hope this helps. I'm going to read from notes so I can help you better. So in the debt buyer lawsuit that we're looking at, so the video is going to have my show notes so you can see specifically how to handle each paragraph. Like the first paragraph of this debt buyer lawsuit, they're really not saying anything. They're just saying we're filing this civil action based on what we say is in the complaint, which says nothing. So your response is always deny if it is true, which ultimately is. If you've packed that counter affidavit, see all my videos on how to create a killer counter affidavit, you will deny and then instruct the court to go to the Exhibit 1. So in my first paragraph, I say denied as Calvary has no standing to sue on this debt with no proof. That theme must go through every paragraph essentially because A, it's true, and B, that's your counter affidavit. You always want to keep closing. All right, so number 2 in the debt buyer lawsuit we're looking at, they continued to state irrelevant information. So I wrote defendant denies, has no way of knowing this. In that allegation they had said, hey, we're in Whitehall, New Jersey. Why they put that in there in the Michigan lawsuit, I don't know. So I just denied and said, like a real person would say, like, why would I know that? So number 3, they wrote, to show they are suing in the right court, they said, upon information and belief. By the way, whenever you see information upon information belief, definition of that is, I have no clue and I don't have any proof. So the law sort of allows you to go upon information belief. Whose information, whose belief? None. And it's the attorney writing it. So that's also a key, like, oh, they got nothing. So defendant is domiciled in the city. That would be my client. And I say, I won't admit anything, even if they got the city right. So I will say, defendant denies owing as to Calvary. So she shouldn't be in this court, meaning who cares where she lives? So I just generally deny everything because plaintiff doesn't have the right to sue my client. In pleading number 4 of the lawsuit, the first real thing that's in this lawsuit, they say my client owes $2,200. I don't admit anything. So I deny as defendant does not owe the debt to Calvary. He or she may owe the debt to somebody, but there's no proof that they owe it to Calvary. Calvary. It's a Calvary SPV1, LLC lawsuit. Number 5, they say number 5 incorporates 1 through 5. Whatever. They're moving on to suing him with the meat of their act. I just say deny. And then number 6, they say, okay, this defendant took out a credit card. In this case, they say the account at issue was transferred, sold, or assigned. Well, there wasn't an account. There was a debt. Get into your head that debt is not account, yet 99% of your lawsuits will say account instead of debt. Look at the definition of account. It is not a debt. It's like saying, based upon the oil changes, Mr. Smith owes this debt. It is based upon a debt, not an account. Again, read this carefully, as they never say you owe a debt. They say you owe an account. I don't know how you owe an account. You can say he owes me an accounting, but that doesn't mean you owe a debt and that it is owned a debt. A debt is owned. So I deny this allegation. I deny there's an assignment missing. I deny they don't have proof. And again, I refer to my Exhibit 1 and Exhibit 2. When you look at my membership website, and you will see my show notes that perfectly, not perfectly, but it instructs you how I answer these, and I think it gives you a lot more information than most answers, which are out there being charged from $50 to $100 to $200. In number 7 of the lawsuit, they say that defendant into a contract with plaintiff's assigner, in this case it was Synchrony Bank, for goods sold and delivered and services rendered on an open account. They're sort of going around what's called an account stated statute, but they never really allege that. But you didn't sign up for an account, you signed up for a debt. So that goes in my paragraph 7 response, along with my denial, along with my Exhibit 1. You'll see my show notes. That the copy of the contract is attached at number 8, or alternately the contract in the possession of the defendant. No and no. It isn't attached, and it isn't in the... I'm not doing their work for them. My client's not doing any work for them. Denied. There's no proof that you have the right to sue my client. 9 through 13 of the complaint that I have attached to this video is all the same. It's just a repeat of a contract, the plaintiff has accounts, blah, 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 blah. My response to that nonsense is all the same. Deny, deny, deny. See Exhibit 1 showing all the things that they have not brought. They don't have to be perfect, but could you at least do a minimum of the work, which they don't, because they expect you to default. Don't let them get away with it. Don't help them beat you, because you can beat them easily with this stuff. So you're going to look for a template of what I do in my show notes. I've attached answers to debt buyer lawsuits for you in my membership video for LVNV, Midland Credit, a company called NAR, UHG, Velocity, and also another Calvary answer. They are in Word, meaning you can use them as long as you incorporate your state's information and don't follow my legal expertise, if you will. I'm giving you a template. But I've given you like several Word answers in my membership website. More importantly, once you're done, once you've got your answer, you've got your affirmative defenses, which again, affirmative defenses will reference your counter affidavit, and they would say like, I don't have an agreement with Calvary, see Exhibit 1, my counter affidavit. They are suing me on a debt that I haven't paid on in 6 years, see Exhibit 1, if that was in your Exhibit 1. So you'll see I have affirmative defenses. Again, use your state rules and affirmative defenses if you're not in the state that I did that in. But I want you then to print 3 copies of your finished product, sign the answer, and I also incorporated for you a proof of service, a certification of service. Take the answer, get it time-stamped at your court so they can't lie and say you didn't get your answer on in time, and then send certified return receipt requested, a copy to the other side, depending on how many other people are suing you. Keep a copy for yourself. Make sure the original goes to the court. That's important because they're going to lie and say you never answered in time, and then they'll default you. Seen it, been there, done that, had to fix it. So these are instructional show notes for every way that you answer a lawsuit, a collection lawsuit from a debt buyer. Again, remember the 5 things. Break up the lawsuit, look at the documents, and just ask yourself, how does this prove anything? I have a debt, I don't have an account. Highlight with your highlighter what's wrong with it. Create your affirmative defenses based upon what's wrong with it. Create your counter affidavit and refer to the counter affidavit exhibit 1 in your affirmative defenses and your counter affidavit, and make sure you get the whole thing filed with the court and time-stamped copies so you can prove you did what you're supposed to do. This will put you in such a good position to settle the debt, to scare them off. You don't want to be defaulted. The very purpose of my doing this today is to give you anxiety-free responses that get you in a position where you're not going to be defaulted. So I've gone a little longer. I don't like to do that. Everybody says, stop doing it so long. Usually my family telling me they don't like me going on and on. But it was important that I get you instructions today. I hope you don't mind. Go to my membership site, collectionstoppersolutions.com. And as I said, I've got all the templates you need. Subscribe, please. Like, please. I have an ego. But the more you do for me, the tons more I can do for you. No money asking you to go click. All right. Thank you. I hope I didn't say too much. Have a good day.